All right, good morning, everyone. I will call this meeting of the Jackson County Planning Commission to order. It's 9:01, April 9th, 2026. First, it looks like we have minutes from December 11th and February 12th.
We need to do roll call.
We need to do roll call. Why don't we start with that? I think that's a great idea.
Commissioner Snyder,
Present.
Commissioner Galpin,
Present.
Commissioner Elliott,
Here.
Commissioner Lavanino,
Here.
Commissioner Wallen-Daly.
Present. Now we have minutes from December 11th and February 12th. Did anybody have any changes? Nope, everything looked good. Can I take a motion to approve the minutes?
I'll make that motion to approve the minutes for February 12th.
Oh, you don't want to do the vote.
Can we do December also?
We could do them
I
too.
only have one, do I? Oh, no? I have no comments on the other one, so we're,
December 11th.
I think December 11th and February 12th are the
Okay.
dates.
Are you doing them both
Yes.
or not?
Yeah, we can do them together if you...
let's do it that way.
Okay. All right, we have a move and second, so can we call the roll, please?
Commissioner Snyder,
Approve.
Commissioner Galpin,
Yes.
Commissioner Elliott,
Yes.
Commissioner Lavanino,
Yes.
Commissioner Daly.
Yes. All right, and we are going to open a public hearing. The first public hearing this morning is for Jackson County Planning File 43925000005-LRP. Do I have that right? Yes, I think I do. Okay. This is a public hearing on consideration of a minor comprehensive plan map and minor zoning map amendment for an exception to statewide planning goal 11 to allow the connection to a future Rogue Valley Sewer Services sewer line and to add 14 parcels consisting of 19 tax lots to area of special concern ASC 2003-1 goal 11 exception areas on a total of 797.55 acres, zoned woodland resource, exclusive farm use, rural residential 5, and rural residential 2.5, located at 58 North River Road, 2765 Second Avenue, 52 North River Road, 86 North River Road, 94 North River Road, 175 North River Road, 40 North River Road, 101 North River Road, 215 North River Road. Del Rio Vineyards, LLC, Robert and Julie Wallace, Lynn Steele are the applicants. There are a number of items that I am required to address prior to the start of this hearing. Approval criteria used in making this decision are listed in entirety in the staff report. Please direct your testimony and evidence toward the applicable approval criteria. You may also direct your testimony to other criteria or policies of the comprehensive plan, land development ordinance, or other land use regulations which you believe apply to the decision now before the Jackson County Planning Commission. Remember that a failure to raise an issue accompanied by statements or evidence sufficient to afford the Planning Commission and other bodies an opportunity to respond to the issue will prevent appeal on that issue to the Land Use Board of Appeals. All applicants who wish to speak must sign up on the sign-up sheet provided. The county is making a verbatim recording of the hearing. In the event of an appeal, it will probably be necessary to transcribe it. Therefore, when you testify or comment, please speak loudly and clearly so that your testimony will be recorded. Begin by identifying yourself so that anybody reading a transcript of the recording will know who's talking. We need to have you clearly identify yourself with name and address for the record. Any written comments or other items of evidence must be submitted to the clerk to be marked as an exhibit for the record. The procedure for the hearing will be as follows. First, the commissioners will indicate whether or not they have had ex parte contacts or have conflicts of interest. We will then have a staff report from the county planning staff. Commissioners may have questions of staff at that time. Third, we will hear from the applicant. And fourth, we will hear from those in favor of the amendments. Next, we'll hear from those opposed to the amendments. Sixth, we will hear from those wishing to speak from a neutral position. And seventh, the applicant will have an opportunity to respond to any testimony or evidence. Testimony from the public and agencies will be limited to 5 minutes. Anyone needing more time to testify than allotted should submit their additional comments in writing. And finally, once everybody has had an opportunity to speak, the public hearing and associated public record will be closed. Unless the public hearing is continued by the commissioners to a future date, the public hearing will be closed for deliberation by the commissioners. And then we'll call for a motion and deliberate and all of that. So it looks like we're ready for the staff report. Dawn? Nope, because we have to do ex parte. Sorry, first meeting. Could Patty call the roll and ask if anybody has any ex parte conflicts, or ex parte contact or conflicts of interest?
I have none.
I think we'll do a roll call if you don't mind.
Oh, okay.
Thanks.
None.
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 None. And now Dawn.
Good morning, Commissioners. I'm Dawn Cox, Planner 3, 10 South Oakdale, Medford, Oregon, 97501. The application before you is a request for an amendment to the Jackson County Comprehensive Plan by taking an exception to the statewide planning goal 11 for a total of 797.55 acres. I would like to point out an error in the record on page 31 of the record, page 2 of the staff report. The background paragraph should read, accepted as complete as of November 19th, 2025. It said 2023, and that's incorrect. The zoning map shows the subject parcels in yellow. I know it's a little hard to see underneath the wildfire hazard layer, but the bright yellow is all of the subject parcels. This is a map of the subject properties in relation to the proposed sewer line. And the proposed sewer line, as the staff report mentions, is through, it was a type 2 application, a different application entirely, for a 8-mile long intertie sewer line from the Gold Hill sewer facility all the way out to Blackwell Road. But that's not what we're discussing here, that's just a point of reference. Here's a list of the applicable Goal 11 exception criteria for this case. The criteria shown in red have not been met. I have the record page numbers if requested from the Planning Commission. No documentation was provided in the record from DEQ or Oregon Health Division as evidence that no practicable alternative to sewer system is available for all 14 parcels. Proposed, planned rural uses and future minor commercial activities are not further identified as part of the justified uses required for a Goal 11 exception. Not all of the uses proposed to hook into the future public facility have been identified or justified. There is a lack of description for the future rural uses and future commercial uses that are in the findings submitted with the application. Without listing all the specific uses on the subject properties, external impacts cannot be completely analyzed. And because the uses for every subject property have not been disclosed, more than half of the subject parcels have a listed use as unused. Zoning does not equal uses, so just because it's zoned a specific way does not equal approved uses. No exception to statewide planning goal 14 is sought. However, 5 of the parcels are less than 2 acres and are currently vacant. A direct consequence of connecting to sewer is actually urban level development. DLCD states that if a property is 2 acres or less, that it is urban by design. And basically, what I stated with the Goal 14 exception is due to the property's size and the unused portion of it. So that's why Goal 14 is shown there in red. The evidence submitted by the applicant does not support the approval of a minor comprehensive plan and zoning map amendment for an exception to statewide planning goal 11 to allow the connection to a future Rogue Valley sewer services sewer line and to add 14 parcels totaling 797.55 acres to area special concern ASC 2003-1. For this reason, staff recommends denial. Should the Planning Commission disagree with the staff's recommendation, additional findings from the Planning Commission will be required. Are there any questions of staff from the Planning Commission?
It seems to be that one of the, obviously the primary issue is the lack of identification for future use. To what extent is the applicant required to identify the uses? How precise does it need to be to satisfy that requirement?
Well, the statute says that the uses that are approved are the only uses allowed to be hooked up. So use is important.
So if they, Dawn, if they had only asked to hook up to the uses that are identified, would there still be objections?
That would be a different application. This application asked for all of those 14 parcels. So we don't have a way to take this application and then cut it down to just the ones that have the listed uses.
That's good, but that wasn't my question. So what if they had applied to put sewer just to the ones that are identified? Would these objections still apply generally?
No.
So it's mainly, like Mr. Goffin says, it's an identification problem.
Right.
Okay,
Yeah,
thank you.
if I could add a little clarification, that one of the parcels is where they actually have the letter from DEQ, is that the septic system wouldn't be able to handle the volume that would be coming out of the tasting room. If that was its own application, the use is identified, the problem is identified, and we can move forward. So it's exactly right that the problem is that they're asking for 14, and I believe it 8 are unidentified. If they were on a separate application and the uses were identified, or let me back up from that, if the ones that had the uses were identified, there is a vehicle for us to get there. But without knowing what the use is, it gets back to the zoning versus the use. Some of them may have a single-family residence, some might be vineyards, some might be whatever, but we need to know what that use is that's getting hooked up to the sewer line. And I'll diverge completely off here and throw an opinion in it. If we can get something and get it hooked up to sewer, it's much better than having a septic system. But these are the rules that the state has given us, that we have to have an exception. The idea is that they're protecting resource land, and we shouldn't be hooking up sewer up to resource land because then it becomes more urban character. You can argue all that you want, but these are the rules that we have in place. So we need to know at least what is that use so we can say, tasting room, there's no way they're going to get the septic there. It makes more sense to hook it up to the sewer.
So is it as simple as stated use? Or do they need to, like you said, is there a completely different application for each of those usage?
Go ahead, I probably said too much.
Not necessarily. So if this application had the listed listed uses for each of the 14 parcels, then we would review those listed uses for, well, all of the state criteria as well as our LDO criteria.
So would they have to get homesite approval first to get that approval, or is that?
Not always, but there still needs to be a listed use. We have done Goal 11 exceptions for, okay, this is what is there now, but these are our planned uses because the bundle of uses is what's going to be tied to the property. So what's approved is the whole of what was listed. And beyond that, that's not approved. So the uses are very important for Goal 11.
Okay, thank you.
So can I ask one more question? So if you had, if they had identified the actual use of each parcel, you could have moved this forward and served the parcels that do qualify?
Maybe, if they all met the criteria, that's the whole thing. I can't analyze the criteria with an unused use. I have to analyze each of the uses up against the criteria for the Goal 11.
So if they had still identified the whole area and then said this and this and this and this parcel are the ones we want to hook to the sewer, you could have moved that forward?
So are you talking about all 14? Your question is getting a little lost with translation to me.
There's 14 parcels, say,
Right.
and they identify 7 of them, whatever the number might be, that meet the criteria for sewer service. Could you have moved it forward? And then they had said the other 7 don't qualify
No.
at this time.
No, because it's all or nothing with the entirety of the subject properties.
Okay, thank you.
You're welcome.
It would become a partial approval at that point. We can't give a partial approval.
So if it was a subdivision, you could do that. If it was a platted subdivision with 14 lots, you could do that, is that correct? You could approve the sewer.
Only if the subdivision was for single-family or duplex homes.
Oh, that, I meant,
You have
excuse
to,
me,
you have to state the use.
I presumed that it was
Yeah.
a
Well, you could have a-
subdivision for housing. Thank you.
There is reference to Goal 14, and I'm unclear in the staff report whether you've determined that Goal 14 applies or not.
The reason that I mentioned Goal 14 is because some of the unused parcels are less than 2 acres, and that's an urban level size of property. So depending on their uses, which we don't know, that's the reason that I brought up Goal 14, is because it's still an unknown. And the applicant mentioned in a generic way commercial uses, but I don't know what those uses are. There was no specification of the commercial uses. And with all those unknowns plus the size of the lots, Goal 14 is urbanization.
I guess I just don't, maybe this is me being thick, that's possible. If they're vacant, I think, so the terms unused and vacant are being kind of,
They're the same.
okay. And then if they're vacant, how could they tell you what the use is, other than vacant?
So we can't hook up a use to the sewer that's unspecified. We can't hook up a parcel to the sewer that doesn't have a specified use. Part of the criteria for Goal 11 exception is that you have to identify and justify the use. So if it's a vacant piece of property, then identifying that the use of that property can be justified to need the sewer hookup. The state statute says you've got to justify, you've got to identify and then justify the use.
Let me give you an example that if it was a difference between a single-family dwelling or the tasting room, and you were applying for the septic system, obviously different size septic systems. So it works the same way when, like the tasting room, if the capacity is the point that it can't get the septic system, well then the logical alternative, or only alternative, is to go to the sewer. But if you had a single-family dwelling, you might be able to get there with the septic system, and DEQ, at that point, they would decide whether or not there was a problem, or a hydrologist or somebody would identify a problem that you couldn't get the septic system. So in order to get the exception to say that you can go with the sewer, you need to know the use to see whether that exception is a valid exception. And again, I'll get back to my commentary. I wish that the legislature would clean this up, but these are the rules that we have in place, so.
So it says on, excuse me, exhibit number 26, page 403, applicant requires defined, or they speak to their defined uses a little bit further, where they say residential uses are intended for residential use, agricultural parcels will remain in agricultural use, and the tasting room is already approved, and I'm assuming that the tasting room is the minor commercial use that they continue to reference. So if they were to remove that throughout the application, would that then show that they are defining all of their uses for the application?
I can't assume that.
But I'm saying, so if they,
That's the zoning.
okay. Because they say no commercial rezoning is proposed, so if there's continuing on, if they're saying all residential uses will continue to be used for the residential spaces, how is that not defining the use?
So they've submitted a use table, but they didn't submit.
Apply them to specific parcels?
Right,
Okay.
right. And that's the real key. In the commercial use, they didn't specify that. The commercial use itself was the tasting room. They just kept saying commercial use. So without that specification, how do I analyze?
So I hate to keep being confused, but I am. Is the underlying zoning mainly RR5?
Not mainly on acreage, but there is a lot of RR5 in the zoning through the subject parcels. There's also woodland resource and exclusive farm use. But
I guess
zone doesn't equal use.
I got you.
Yeah.
Say if they came, though, in the RR5 zoning, they came and said, we want to sell these parcels as RR5 dwelling units. Would that then allow them to ask for the sewer to be extended?
If they had specified location of future dwelling, location of future single-family dwelling, those types of details would have been very helpful.
So a building envelope or something on the parcel?
Not even necessarily a building envelope, just the words stating what they want to use the parcel for.
Oh, okay. How much of them, this is maybe beyond the scope of things, but how much of it would then have been resolved? Most of it, or?
I would hope so, but I can't.
Sure.
I don't know the answer to that.
Thank you.
Do we have any other questions for staff?
Have you ever noticed how Dawn knows all the answers?
Isn't that?
That's really refreshing.
Yeah. Okay, I think we're ready to hear from the applicant. Is that right?
Yes.
Okay. Come on up.
Good morning. There we go. Garrett West on behalf of the applicant. My address is in the record. I'm going to pull up a poster. It is already in the record, so we don't have to worry about that. This poster kind of shows the lots that are closest to the river. There are more parcels involved in the previous map we showed. Staff, could I have the map on the PowerPoint of whichever one of them is easiest? That'll work. Thank you. So you can kind of see the EFU and the vineyard land. That's the bigger parcels in general. And there is some woodland and forested areas as well on the periphery of this area. So number one, Great questions, because this is exactly what I wanted to talk about. My application could have been cleaner, and I want to share a little bit of history and explain why things kind of got a little confusing so I can clean that up for you. The commercial uses that I talked about in the application. A year ago, there had been pre-application conference talking about a Goal 11 exception and a zone change. So originally, you were supposed to see a zone change application today for some kind of commercial rezoning. And so there were some leftovers in my application because I assumed we were still going forward with that. And so just some communication errors on my part, and I apologize. We're not moving forward with commercial uses on these kind of riverfront properties. We're just going for residential uses. And so there's that use table that I spoke of, like unused for some of the lots. When the application was deemed incomplete, staff asked me for a use table, and I thought they meant the uses that were currently existing on the properties. And I'm like, well, there's nothing on this property we'd like to build, but we kind of need a Goal 11 exception. So we kind of got into this circle of miscommunication. So again, for these riverfront properties, we just want to build residential because this is RR5 and RR 2.5 properties. There is our tasting room that's been approved, and that is Parcel L, which is kind of across the street. And then Parcel M, which is all next door, and then a lot of this vineyard area as well. That's being used for the vineyard and the winery and that kind of use. So we're not proposing residential for that. So I hope that kind of clarifies things and kind of sorts things out a little bit for the commercial. There was a question of, well, they didn't do this perfectly, and so we can't approve any of the application. I disagree with that. It's not the best, but you're the planning commission. There's no statute, as far as I'm aware, that says you have to do a land use application perfectly, and if you don't do it perfectly, scrape it, apply again in a year, and then we go through another year-long process. So if you think that any of these parcels or lots comply with these statutes and these rules, you can apply the Goal 11 for those specific lots. You can say, hey, I don't think it applies to this one, so we're not going to approve it for that one. I think that's totally a reasonable thing that you're allowed to do. With the questions about the RVSS letter, so there are 3 tax lots that are in this application that we did not get an RVSS letter for. 2 of the tax lots are part of the larger winery and vineyard complex. And that's the one at the very top of the PowerPoint and the one to the very far right of your PowerPoint. And the reason those 2 tax lots were included is they're one parcel along with Parcel M. And so I wasn't sure that I could ask for just tax lots to be approved instead of a lawful parcel. Because tax lots are just for assessment purposes only. They're not really for planning purposes. So it's a little bit of nuance there, but if you said, hey, we don't want those 2 parcels in the Goal 11 exception, sure, you can do that, I think. And then there's one more lot that's included in this application that we didn't get an RVSS letter for. I forgot to go get it, but I don't think you need an RVSS letter for that. The standard is feasibility. Is it feasible we can connect to RVSS? And RVSS has said they have capacity for this, which makes sense. They're building a new line all the way to Gold Hill. They've annexed Gold Hill into the RVSS system, and they're willing to allow us to build a long sewer connection just for this specific area. And I don't think one of these tiny little lots is going to make or break the system either way. So I think there is capacity, and I think there is substantial evidence in the record to back that up. On the DLCD comments, I do want to publicly apologize to Josh LeBombard. I should not have been that aggressive in my letter saying that DLCD generally opposes all development. Was having a bad day. So Josh, I know you're listening. I apologize to that. I think my frustration often comes with what I see is kind of contradictory standards from the state a lot of the time. You see other applications where the state opposes development because they think it'll result in environmental harm, right? You can see that in some aggregate applications that they oppose because they think it'll hurt deer, for example. In this one, we have septic systems right next to the Rogue River. And there's a letter from one of our experts in the record that says this Because location, there is a significant danger that, frankly, when it rains, the rain is going to go in the septic system and push out items into the Rogue River that should not be there. To me, I see this as a very pro-environmental application of, like, of course we don't want to pollute the Rogue River. People drink out of the Rogue River downstream. It just made sense to me. And so seeing that kind of contradiction, I got frustrated, and I shouldn't have just said that to DLCD. But I hope that provides a little context for what I'm seeing in regards to this application. And I do want to throw in the record, just for purposes of appeal, I do think the state's stance on Goal 11 violates the Endangered Species Act. Because when you have pollutants going into the river, it's killing fish. That's what happens, and we don't want that to occur. Now, approving this would also allow us to develop these parcels for the residential uses and the tasting room that we're looking for, but I think that's also an important consideration, that, we don't want to cause environmental harm while we're doing these things. So those are my main points to address. In my read of the staff report, it did concentrate on, you talked about future commercial uses, and you didn't list those, so we can't approve this application. I want to just strike out the commercial uses. We're not going to go forward with those. In the future, if we wanted those, we'd have to come back for basically a modification of this. But we'd like the Goal 11 so we can build some homes on the riverfront in a way that just makes sense. If you have questions, I'm sure you do, I'd be happy to answer them. And I do have my clients here as well who might want to say a few words.
So Garrett, I guess from what I got from your speech there, then you're not proposing the wine tasting rooms or storage sites and things like that to be approved with this effort today?
No, so number one, we're not asking for approval of those kind of things, and I'm not proposing those.
But it's proposed in the future?
So for the tasting room, we do have approval. And for that specific one, I am asking for the Goal 11 exception for that, because it's already been approved. We have no plans for anything else in the future commercial-wise.
And I was a little unclear when you were mentioning the difference between a lawful parcel and a tax lot. Why does that matter, and what's the difference?
Oh, great question. I have an appeal with Jackson County right now on parcel legality. So a lawful parcel is determined by planning regulations, right?
Is that on a map then?
Basically our maps. It's a little more complicated because I have to often go through historic deeds to figure out when was this parcel created in the 1800s. Tax lots, they're created by assessment upstairs. Today, they can go and they can draw a line on a map without any application or approval from us, or they can start consolidating tax lots. Oftentimes, these two things, parcels and tax lots, they're the same. But once we get kind of far out into different parts of the county, they do diverge. And this is one place where they diverge. And so, like on this map, you see parcel M, which is, let's see, I think it might be in kind of blue in the middle of the map near those big buildings. Parcel M also takes up all the vineyard you see on this map as well. That's the same parcel, even though there's different tax lots. And so just a rule of thumb is tax lots are for assessment purposes only. When we're doing planning, we have to look at lawful parcels. So that was kind of the reasoning behind that.
So on your table, on page 32, when it talks about land uses and things, you've got 3 listings for parcel M and 3 for N.
Mm-hmm.
That's the only ones you have on there. So you're saying that's one tax lot M,
Yeah.
but 3 parcels of M.
Yes.
I guess, again, so what? How does that help us today?
That was just explaining why 2 of these tax lots I included, even though they hadn't been mentioned in the pre-application conference, even though I hadn't gone and gotten an RVSS letter from them. I thought I was required to include those 2 tax lots in this application.
Thank you.
I had a question about DEQ denials in your letter that we got yesterday. It's page 392 of the record. It says nothing in OAR 660, et cetera, requires an applicant to obtain individual DEQ denials before seeking a Goal 11 exception. And it has sounded like maybe that would be a preference of agencies, maybe, for you to have provided, like, gone through the whole DEQ process first. But it sounds like what you did was have a hydrogeologist, didn't know that was a job until yesterday, go through and assess all of the different parcels and make that determination rather than going through the DEQ process. So I guess I just wanted to, I don't know,
Totally.
just ask that on the
No,
record.
I understand what you're asking. So when you read the text of the rules, it says you need to demonstrate there's a public health hazard, number one. And I think we have done that, given how close these are to the river and downstream uses. And it says, basically, you can get a DEQ denial, and that proves it. But it indicates that there are other ways to prove this. Now, the state's interpretation of this is that only a DEQ denial will work. And they have maintained this position for a few years. I've done pushback. My law partner, Dan O'Connor's done pushback. That's their stance. I don't agree with that's how the rule is written, just based on plain language. So that kind of gives some context. And unfortunately, due to some budget issues, DEQ is, I'm not going to say impossible to work with, but I can't even get an appointment to go to DEQ. They used to be able to go up and, like, have an appointment to see them in person to talk about specific sites. Gone. You're kind of between a rock and a hard place. It feels impossible at times to do some of the development we want to do. And, like, septic is, like, it's maybe not step one in the whole process, but it's so early. It's just like, okay, we got one denial. Great. Like, that's what we need. So that's kind of the context behind that.
Okay. I guess that was my other question, was just, I'm sure it was quite a process to hire your own person to go out there and do this assessment. You kind of answered my question, I guess, because my question was, how difficult is it to get DEQ to do each and every one of these parcels? Because I know that they're backed up and having a hard time getting through their backlog right now. So since it's not, is there a statute that requires a DEQ denial, or this is all dealt with in this OAR?
This is all dealt with in the OAR.
Okay.
And yeah, same thing with our hydrogeologist. The reason you got that kind of late, I think it was last week maybe you got it, or maybe this week, it was because he's backed up too. So it's a whole system, public and private side, that's just like, please give me your work. It's taking months, but there we are.
Okay.
So not to beleaguer this use table conversation, but what was the aversion to just quickly amending the application to remove the commercial language and then resubmitting a new defined use table?
I didn't know this was a problem until the staff report came out last week. And so I had no idea this was any problem. I would have, of course, amended. I would have put something in the record that says, ignore all these commercial uses. Let me physically strike it out in the application and give you something cleaner. But that came out. And so by Monday, when I was able to read things through, that's when I'm, like, rushing to clean up the record a little bit.
Okay, thank you.
Does anybody else have any questions for Mr. West? All right, did Mr. Wallace want to come up and talk? Just please state your name and address for the record. Thank you.
I'm Rob Wallace, and I live on 40 North River Road, actually one of these tax lots that you're looking at. I don't even know where to start. I didn't prepare anything. I thought this was a slam dunk. Only I was told it was a slam dunk. For 25 years, we have been trying to do the right thing on the property that we bought back in the late 90s. We took a failing pear orchard and turned it into Del Rio Vineyards, and since then we have done nothing but try and improve all of those properties. In 2000, I think it was Craig Stone that I applied for a pre-application conference to change the river property at that time. This was about an 800-acre ranch that we bought from the Hobb family, or the Dual family. And the property along the river was part of the farm parcels that wasn't divided into tax lots for dwellings. And so we had this conference say, hey, can we put some homes along this river, clean this up? There's no water rights. It's all cobblestone. It's not worth shit for farming. Can we clean this up? We're going to put vineyards in the farm ground. We're going to put houses on the river. We want to really develop this and make it all look nice. I was 33 years old, so that was 25 years ago. In 2014, 14 years later, we were finally issued the final Mylar plat map, or whatever they call it, and it was submitted to the county, and those lots that you're looking at were approved. It took 14 years to do that. There were a few lots that had been established prior to that we did not own, and over the years, a few of them, some of them were drug houses that we went through this county and worked on a lot. We finally have bought the last of the drug houses. We've eliminated them. We've cleaned them up. And so we've got to the point in this development process after 25 years that we want to start building some nice homes. We've had people ask us if they could buy the lots. The reason the commercial thing came up, some gal wanted to build a day spa. And Dan says, well, I'll go ask the county if we can put a day spa. And I said, you know what, I don't really like that idea anyway. I'd rather do it all the same and make it all look nice so that the houses tie together. So that's the direction we went on that. In 2008, we bought the lot next to us from Jimmy Brotherton to expand our tasting room. Our tasting room is a house that was built in 1863. It's on the National Register. We've been maintaining it under the historic rules, under the whatever book it is. It's been a project, but we've been in that thing for 25 years. It's open every day of the year except for Christmas and a couple of holidays. We've done it for 25 years. We've completely outgrown it. We want to build a new tasting room. We bought that lot from Brotherton. 6 years ago, we started working on getting a permit to build a new tasting room. Here we are 6 years later, we're still talking about it. I'm $100,000+ in attorney fees just trying to get a permit to build a tasting room. I'm intimately familiar with every single parcel here. I have turned over every rock, I've pulled every weed, I've cleaned it up. If you want to know what my intention is on any one of these 14, I can tell you exactly what it is. We're going to build houses on the river lots. We're going to build a tasting room on the lot we bought from Jimmy next to our existing tasting room. And we're going to maintain our existing use in our winery. I mean, ask me whatever you want. But, I mean, this is becoming a multi-generational process to get a permit out of this county. It's just ridiculous. And I apologize, but it's just been expensive and frustrating. My son now is 35 years old. He's the age I was when I started this project. Anyway, if you have any questions, happy to answer them, but So our existing tasting room has a water meter on it that runs 43 gallons a day, average. 25 years we've had a water meter on it, and we have to keep track of it for DEQ, all this BS. So we know exactly how much water goes through that tasting room, and we know exactly how many cases of wine we sell. So if you take all of the water that goes in and all the wine that goes in and pour it down the drain, it's going to be less than 100 gallons a day. DEQ came in to give us a permit for our new septic for a new tasting room to replace that one. They wanted a 5,000 gallon a day system with 3 or 4 tanks. They wanted us to go under the railroad tracks, out into the vineyard, remove vineyard. And I just said, you know what, screw it. I don't even want to build another tasting room. It's ridiculous. And I was driving through town and I said, shit, there's the city system. Let me just use that one. And so I called the city. She said, we sold it to RVSS. Call them. So I called RVSS. They said, sure, no problem. We'll take your money all day long. Happy to help you out. They said, but you got to get an exception to go 11. So that's how this started. Then you got to call ODOT because you got to put the line on the ODOT's right of way. So we called ODOT. ODOT says, no problem. You can put it in there, but you got to call 5 Indian tribes. So we called 5 Indian tribes, and 2 of them responded, 3 of them didn't, gave them the time. So ODOT's good, RVSS is good, everybody's good, except for Jackson County. And we're trying to do the right thing. When we did the comprehensive zone change, we had to prove that all of the properties that we developed for rural residential or for single-family dwellings had adequate soils, whatever, in order to provide for septic. We did that or they would have never gave us the zoning, right? That was part of the process. That's why it took 14 years. And here we are, and we're just saying, I'm not going to build the tasting room if I have to put in a $500,000 system and rip vineyard out. It just doesn't make sense.
I have a question. DEQ told you to take farmland, EFU farmland, and put in and rip out current crops and put in a
Yeah,
septic
there's
system?
not room for 18, the lot that we're putting the tasting room on, shit, it's not that big. They wanted 1,800 feet of leach field, and the only place I can put it is going under the railroad right away and out into the vineyard and take out vineyard and put it out there somewhere.
Okay.
I mean, this is just such a frustrating process, and I apologize, but I've worked on it for literally 25 years. I haven't built a single house. I've been here 25 years. We pump $10 or $15 million a year into this economy around here. I got 100 employees. I mean, we do a lot for this community, and I just feel like, you know, what's the problem? Why is it so difficult to get a permit? Anyway, if you have any questions, I'm happy to answer them. Apologize for being frustrated, but it's
We
the process.
appreciate you being here. Does anybody have any questions for Mr. Wallace? Okay. Thank you.
Thank you.
And I have Jolie signed up as well. Would you like to come up? Name and address for the record, please.
Jolie Wallace, 40 North River Road. I don't speak as well as my husband off the cuff, so I had to write something down. I'm here today on behalf of Del Rio Vineyards in support of our request for Goal 11 exception. This request is not introducing a new direction. It's a continuation of a long history of county-reviewed and approved land uses decision on this property. Looking at the timeline, this property has been carefully reviewed and shaped over many years. In 2010 and 2012, property lines were adjusted, partitions were reviewed and approved by Jackson County. In 2012, the Board of Commissioners approved a comprehensive plan and zoning amendment that established how property could be used moving forward. Since that time, the property has been operated in that framework. And now, in 2025-26, this application has once again gone through a detailed and thorough review by the county staff. At every step, the county has evaluated this property and supported our path forward. This request is simply a next step to that progression. We've determined that the proposal meets applicable land use ordinance criteria and development on the parcels is feasible under all required standards. Protections for surrounding resource lands, required setbacks have been clearly addressed and will be continued to be enforced throughout future permitting. One of the most important findings, I believe, is the process is related to transportation. Both planning staff and the county engineers have determined that this proposal will not negatively impact traffic, safety, or surrounding road systems. Even when considering similar properties in the area, there is no significant cumulative impact. Because of that, the transportation impact study required was waived. This is not a request of expansion or increased intensity. This is about being and having responsible infrastructure. It is a limited request that allows for future connection to sewer infrastructure, something that supports responsible long-term planning. We also recognize that this decision like this matters to the community. This property has been thoughtfully managed over time and requests continue that some approached. We be measured, consistent, and aligned with prior county decisions. In summary, this application follows the clear, consistent timeline of the county approvals. I believe meet all applicable land use criteria, creates no transportation or safety impacts, and represents a logical and responsible next step. Based on all of these findings, we respectfully ask for your support of this Goal 11 exception. Thank you. Any questions?
Questions? All right, thank you so much for your comments. That is all the people I have signed up to testify. Mr. West, did you have anything that you wanted to just close with, maybe?
I forgot to mention the Goal 14 issue. I don't think this calls for an exception for Goal 14. We're not urbanizing this area. We want the Goal 11 specifically for the uses that this area is zoned for, which is rural residential use and EFU, and our tasting room that's already been approved. So I think there is substantial evidence in the record to meet all the criteria, and I think there's substantial evidence that there's a public health hazard when you have septic this close to the river. And I think this just genuinely makes sense. I don't think there's impacts on other properties. I mean, it's a septic line, right? I'm not building industrial things out here. It's going to be in the ground. No one's even going to see it. So just wanted to add a little context. If you do have any last-minute questions, I'd be happy to answer them. But otherwise, thank you for your time.
Go ahead.
I'm just speaking for myself, but it seems to me that staff has made a legitimate argument that you haven't done what you were supposed to do. So would you prefer a denial or a continuance?
I might prefer neither. I'd prefer an approval. If the commission is leaning towards a denial, I'd prefer a continuance so I can, correct some of the stuff in writing. But when you read the staff report, my interpretation of it is, they mentioned future commercial uses. We don't know what those are, so we have to deny the entire thing. First of all, we're not proposing commercial uses. I kind of explained, how that all came about. And secondly, the idea that if there's one parcel or one lot on here that doesn't meet the criteria, the whole application is kiboshed, that's not right, right? You can just say we approve it except for this lot. So that hopefully adds some context.
Would those lots in question just be the ones that are smaller than 2 acres? Is that kind of what we're talking about?
I don't know.
Like if you...
Can I get up and
Sure, yes, Mr. Wallace.
So I thought this was going to be way easier than apparently it is. So if there's 14 parcels, Ms. Cox or Mr. Zuck, and you have a question as to what use is going to be on in, just ask me. I can tell you because I didn't realize it was an issue. The premise of this whole project was based on this tasting room and whether or not we're going to be able to build it or not, right? And the idea to put in the line from RVSS was like, well, if we're going to put in this line, it would make sense to hook it up to all of these other residential houses. It's just better than building 10 septics, right? It just makes sense. So if there's a use that you're not sure of, just ask me. I can tell you what it is. We want to talk about it all day. I know what we're doing. I mean, there's the lots on the river, and they're all rural, they're all single-family dwellings.
I think we all completely empathize with you, Mr. Wallace. You just have to remember staff's kind of restricted into the confines of their requirements, so they have to require this of you. It's not that they're trying to just nitpick with you. It's just, this is their job, right? So that'd be, maybe, again, I think it may be a little bit of an exaggeration to say it's a year to come up with a new use table and all of that. I think there's obviously a path forward, even if, and again, this is something we can deliberate, I guess, but conditioned approval around, submitting a new defined use table, amending your application, striking those commercial uses out, and I think you will satisfy not only DLCD's comments, but staff's requirements as well.
Totally, and I hope I didn't misspeak. I meant that if there's a denial and I have to reapply, it's going to be another year for that. But hey, if you want me to go through and say no commercial uses in writing or something, yeah, I'll take the continuance.
So you would prefer a continuance so you could do those things?
Hey, if you think I need to, then I'll go through and do it. I mean, the staff report says, hey, you want residential? I'm interpreting things and abbreviating things. Hey, you want residential? That complies. You want this for your tasting room? That complies. You said commercial. We don't know what commercial you're talking about. How can that meet the standards? And I'm saying we're not going to go for commercial.
We want you to erase all the red ink that Don showed us.
Sure.
At the first. That's what we want.
Yeah, I can do that.
Then we can say, you bet, go do it.
Sure.
Can I have a question for staff? Is there a pathway for us to approve this today to avoid the continuance timeline with an approval, with a criteria or a condition approval that they are going to have to amend all of these issues? Is there a pathway for that, or is a continuance with a resubmission or submittal the only pathway?
So the applicable criteria, and now mind you, with the LDO, sometimes we do have a little bit of latitude. With the state statutes, we don't have any latitude. It's the state statute. So it's more than just the use table. With OAR 66011, 61C, no practicable alternative to sewer system referenced in the rule means a determination by Department of Environmental Quality or Oregon Health Division. So we still don't have letters for all the desired parcels that say we can't put a septic system in here. And that's one of the state statutes that's required.
Well, that's an OAR, but
So then this letter that was provided by Mr. Williams would then need to actually list every parcel that he would
All of the
recommend?
subject parcels.
Okay.
Right,
but
because that's what we deal with.
is a letter from the hydrogeologist adequate, or are you saying it has to come through DEQ?
So the OARs specify DEQ or Oregon Health Division, and that was the statement that Mr. West made earlier, that he disagrees with the wording. And the comments from DLCD that we got this morning says the analysis from Alpine Environmental Consultants documents the difficulty and potential impacts of placing septic systems in this area, but does not demonstrate that failure to approve the Goal 11 exception will result in a health hazard in this area. And they further state, because of this, the burden of proof is on the applicant to demonstrate why a Goal 11 exception is warranted for all 14 properties.
Does that imply that they would have accepted the consultant's decision rather than their own, if it had met their criteria?
I don't know.
So I mean, I think the question was, does it have to be a DEQ approval or a health authority approval? Can it be someone else's recommendation that they could sign off on?
I believe that is the exact argument of Mr. West. As far as staff reads it, it's DEQ or Oregon Health Division.
Both of which
Let me,
are horribly hard to deal with.
Yeah, let me further confuse things here, I guess. The OAR specifically calls out DEQ or the Oregon Health Department. So that's what we're stuck with. But those OARs govern DLCD, and if DLCD were to give us some sort of interpretation that says, hey, we could take this alternative, we would take it. But right now, the words matter, and we're stuck with what we have. And if it was just the tasting room or, some of the other properties where we could get there, we would not be here asking for a denial. It's just because of 14 were lumped into one, and we didn't know what they are, and I respect that you know what you're going to do on your property, but we have to go by the application that was submitted to us, and that application did not clearly show that. I would like to address, I wasn't the planner on the case, but I'm pretty sure that we had made the argument that you can't lump all 14 together without giving us more information on it, and that did not happen. That's unfortunate. You know my feelings on if we could hook everything up to sewer. I think that's actually a better solution. Unfortunately, we're a regulatory agency that we have these rules that the state gives us, and we don't get to change those rules. We have some latitude if it is within the LDO, because those are our rules. We can interpret them. We can't make interpretations on Oregon administrative rules, especially when they're not even for our division. DLCD is the one that is the keeper of some of these rules. And they're based on the goals that the state has. The entire intent is to protect resource land and not have expansion outside the UGB. That's probably a bigger argument in all this. I guess my point is we can't give a partial approval. The cleanest way is come back with an application, specify the ones that you want, and I can't say for sure, but we're probably going to get there.
So I'm not going to be able to leave today with a partial approval specifically to the tasting room only, is what you're saying?
That,
Because I'll take that. I can put a septic on every one of those lots. I already know I can, because I had to prove that we had to have pre-approval on that soil in order to get those lots approved in the first place. So if you want me to put a septic all up and down that river, I can do that.
Okay,
We're
first
trying
up-
to avoid that.
Well, can I ask the question for staff one more time?
Sure.
So going back to DLCD's recent email where they say that the letter from Alpine Environmental is not essentially thorough enough, they're not denying that Alpine has the capability to assess the property. They're just saying that it's not complete enough. So if Alpine were to review and be more specific in their letter, is that something that staff would be more confident to lean on against a DEQ denial? Don? Because DLCD themselves does not deny that Alpine even has the right to comment. They just say that they did not comment thoroughly enough.
I can't speak for DLCD.
No, I'm speaking to staff. Is that something that you would feel more confident to assume or to accept rather than a DEQ denial?
let me jump in
That's a
on that one.
question for
We would
legal.
be more confident to accept it, whether DLCD would accept it, and we would want to see the DLCD
Okay.
accepted it.
So you would defer. Thank you.
Chair.
So kind of what you're saying in the bottom line is applicant needs to get through the DLCD somehow.
If it would be for all 14,
So then back to their question about throwing out everything except the tasting room. Is that something that we can do today?
I'm going to defer to county council on that one. They're too quiet over there.
Excuse me. I think you probably could do individual approvals by parcel.
And I concur with that interpretation. Like, there's no statute that says you have to approve an entire application or deny an entire application and then start over. The land use system in Oregon would never get anything done, right? So if you're thinking that some parcels don't meet the criteria, you can say, not today. You can totally do that.
Can you please identify which parcels are the ones that are enacting the Goal 14 requirement?
I don't know.
Mr. Wallace, the ones that are less than 2 acres, which parcels are those?
Those are the ones that we didn't develop. So
Can you identify those on the map, please?
the ones that we developed back in the early 2000s, these three, these are all 2.5, 2.5, 2.5 acres, each of them. This one's 2.5, this one's 7, this one's 5, this one was already developed, and I don't remember exactly what it is. This one was a drug house, we just bought it. I think it's less than 2.5, it just had a house on it, we demolished the drug house. This one was another drug house, is that right?
It's F.
Yeah. So this one was a drug house, I think below 2.5. The ones that we developed are these three and these two. This one has a non-farm dwelling permit on it. It actually has we had, in order to make it a non-farm dwelling buildable home site, we had to install a septic. It has a brand new standard septic system on it. Hasn't been used because we haven't built the house yet.
So those are all approved, Mr. Wallace? The septics on those other parcels are approved?
In order to get these lots that we took out of EFU and put in RR 2.5, we had to prove that the soil that they would give us a septic permit on them.
So you have that approval?
We have that approvals in the county. These ones have recently been actually approved. We're getting ready to build houses on these two, and they've been approved for standard systems. This one, we're getting ready to put a house on this one that we just bought the drug house off of. That one has a system on it that's failed, and we've got it in for a repair permit. This one had a double-wide drug house on it that we removed, and it's got a repair permit that I think was already approved. This one actually had a septic on it way back before it was parceled. So there is actually a septic there, but it's probably not adequate anymore. It would need to be a repair permit. These would be new septics.
So kind of what you're telling us is that it's just the tasting room that needs some approval of some kind for sewage disposal.
The tasting, we want to build a new tasting room next to the old one. We've had that tasting room there on a septic system that's in the backyard for 25 years, and it works fine. I'd like to hook it up to RVSS. It would make more sense because there's really nowhere that's feasible, and it would make more sense to put it on commercial sewer than it would to put in a repair area, right? And so I'd like to hook the existing tasting room and the new tasting room up to RVSS. And if you want me to put septics on everything else, I would. It just made sense when we said we're going to bring the line, the sewer company's down here. So the line's going to come right down the street to the new tasting room. And it's going to go right by every one of those home sites. But if it's a problem with the rules, then forget it. We'll just do the tasting room.
Commissioner Galpin, did that?
So many years. I don't know how many more attorney fees I'm going to pay.
We empathize with you.
Yeah, we're
We're
trying
here
to
to help.
figure- we're trying to figure
public
this out.
servants here. We're trying to help streamline the process.
Yeah.
Yeah, we're here. That's
So-
why we're asking all these questions to maybe.
Yeah.
If we could just do the tasting rooms, then I'm perfectly happy.
So I have a question for staff and I guess council,
Maybe
please. So
council.
is there a pathway for us to do a partial approval with a restriction on obviously specific parcels, we'll call them, and then continue the rest of the parcels to be further defined as required? There's not a pathway for that? Or do we have to continue the whole thing, or
I think there
how
has
does
to be
that
a
work?
continuance.
Okay.
Can I?
Council?
My opinion is you could approve it or deny it on a parcel-by-parcel basis.
Can we approve and continue on a parcel-by-parcel basis?
Can I say, I don't think that's a good procedure way to go about things. You can have a vibe of the commission on which ones you'd approve, but then you'd say, hey, let's have a continuance and give Garrett some time to do some writing to get things lined up. I do want to respond to a few things that were said to clarify my position in the record. Number one, staff indicated there were discussions with me or my firm about, hey, you need, I didn't quite understand, you can't do this for all 14 parcels. I was not part of those conversations. I have no idea what staff is talking about. Concerning the idea that you can't interpret the OARs because DLCD promulgates them, of course you can. Like, you do that all the time. You don't have to go up to DLCD and say, what do these words mean? That doesn't make any sense. That destroys the entire land use system. I do have an explanation in the record, and this is at pages 77 and 78 in the record, and starting at page 186 in the record. And this talks about the DEQ denials and things like that. Now, the wording in the rule says appropriate reason and facts for an exception to Goal 11 include, but are not limited to the following. And then it starts talking about stuff. And it gets into, public health hazard, and that refers to DEQ denials. But I'm looking at including but not limited to. And there's a LUBA case on this, and it's Central Oregon Land Watch versus Deschutes County, 74 or LUBA 755. And I included the case in here. And that says, examples of things would be like a DEQ denial. So like the idea that we have to hang our hat on a DEQ denial for all these parcels and lots, this has been litigated, and LUBA said no, that's not true, because that's not what the words mean. So I want to just stake my flag firmly in the ground on that. If we were required to go get a DEQ denial for every lot, we would have done it. I mean, that's, of course it would.
If you could.
Yeah.
So, there does appear to be jurisprudence on whether you have to have a DEQ denial on each parcel. Yeah, John?
So if we approved the tasting room hookup to the sewer, that would bring the sewer line down the road quite a little ways. Then could they come back with those parcels that the sewer line now goes past and say, we would like to hook into that sewer line, parcel by parcel?
Yes.
And how about extending it beyond where it goes into the tasting room? Could they do the same thing there? Say the sewer line is now within 300 feet of this parcel, can we hook into it?
Right, and it'd still be through Goal 11 exception, so it'd still be this process.
And would it be as costly as it seems to be, or for each one?
if there's specific uses that are either existing or known specific uses to be proposed, that makes our job really easy.
So if they want to put a house, for instance.
Right.
They come and say, it's unsafe to put a septic system in here because it's the proximity to the river. They still have to have Goal 11 exception.
And they still have to have evidence of why it can't, why DEQ is unsafe, whether it's a septic installer. We've seen those letters, DEQ, Oregon Health Department.
But in that case, an installer
We've-
might be able to say this is an unsafe site.
We've seen that. Again, that's not what's listed in the OARs, but we have seen that.
So if I might just add on to that, and one of the things I heard was that some of these properties actually have septic approval. Well, they wouldn't qualify for a Goal 11 because DEQ would say we want to see that there's no alternative. So
Would they qualify under?
that's why we can't do a partial approval and why we need something from DEQ, because they have to look at each one.
So with the tasting room, we can acknowledge that it's not a site that's suitable for a septic system. Is that right?
Correct.
So that seems kind of like a walkover. We can approve that. I don't know, Mr. Wallace, how we can help you. I mean, I think we can do the
You can
tasting
approve
room.
the tasting room, I'm happy.
Okay.
The whole idea of putting the rest of them in there was because it makes sense.
Oh, sure.
And I think all of us agree that it makes sense. Even Mr. Zuck says it makes sense, right? It's the right thing to do for the river, for the habitat, for everybody. But if the rules don't make sense, the rules don't make sense.
I don't think any of us disagree with you.
Right.
So we get the tasting room approved, let's say. What would be your next step?
If you approve only the tasting room and deny the rest of the application, I don't know what our next step is, because if I have to come back with individual applications for all these lots, that's going to cost hundreds of thousands of dollars. We're going to be, it'll be another year, if we're lucky, quite honestly, if we're being required to go to DEQ and get all these things. That's the timeline and that's the cost.
But Mr. Zuck already said that if those are septic approved sites, you won't get a Measure 11 exception anyway.
And I disagree with that. I do, because it still creates a public health hazard. When you have septic systems there and you have rain coming down and it's pushing the effluent through the system, it's still going to the river, right? This is a very...
So you're asking your client to fight DEQ.
No, I mean, DEQ will do what DEQ does. I mean, I don't know how I'd influence them, really. I can't even get them on the phone. I'm saying it would still qualify for a Goal 11 exception. There's still a public health hazard.
Yeah. The application can still be put in. And if DEQ says there's an alternative to the septic system that they would accept, or they accept that it is a health hazard, but considering that they were already approved for a septic system, I guess I should not be speaking for what DEQ may or may not do, but it seems to me that the most likely outcome is they would say, well, you can have a septic system, so there is no alternative. And I do want to point out, I do agree with you. I wish they could all just get hooked up to sewer, but
Mr. Wallace, you said, sorry to interrupt you. I sure apologize. Mr. Wallace, you said you installed those septic systems, is that correct? Or that they had?
No, so there's the two of them at the west end. We just had the pits inspected about a month ago, and they were approved for standards. We have not installed the systems yet. We're still working on the plot plan and the elevations. And so until we get the placement of the house and the wells have to be 100 feet from the systems, and so we have to get all that figured out before we actually place them on the lots and install them. But they've been approved for standards, those two. The other two, I think, he's working on a repair permit to utilize some of what's existing from the previous houses that we tore out. The
previous houses would not meet current standards, correct?
One of them, I think, is fine. The one that, because it was built in the late 90s. And so the septic there, I think, was actually, I don't even know that we need to repair it. I think it's going to work.
okay.
The other one, I think, is going to have to be completely repaired.
Thank you.
But we haven't got a determination on DEQ as to what that repair looks like yet.
So I think Jack asked this before, but I just want to clarify. So if we're able to do an approval on the tasting room, we cannot do a continuance on everything else, so you do not have to completely reapply? That seems,
So you can do a continuance. You can do that. It's procedurally sending part of the application up to the Board of Commissioners while holding part of the application. It's going to get confusing, I think. So I'd say you can take a vibe check and say thumbs up on the tasting room, but Garrett, we're going to order a continuance, go back and add some stuff to the record.
that would be beneficial than trying to go back to individual applications. Is that correct?
Oh, yeah, that's way better. Like, the reason we combine all this kind of stuff in a Goal 14 or a Goal 11 exception is because this is extraordinarily expensive. It's extraordinarily time consuming. And if you're doing it for one area, why am I going to pay, I'm guessing it's probably $10,000 an application at least, right? I mean, so not including all the prep for each application.
Well, and back to Ted's point, I mean, this is a better application. This is a better end product for everybody.
Yeah.
So if I,
That's what I'm leaning for.
if I might jump in there, and County Council, please tell me if I'm off on this, but I don't believe, the question is, can we pick out parcels and say those are the ones that we want to approve and other parcels not? I agree that that's something that we could do, or you could do as the Planning Commission. The part of whether we approve part of it and then continue the rest, I don't believe is possible. It would have to be another application. And that doesn't necessarily mean it's an application for each and every parcel. If they can come in and show us that all these ones along the river have an environmental hazard and DLCD signs off on that, and we can do them in blocks that way. But I think for the purposes of this hearing, we either have to have approval, denial, or continuance. You can approve the ones that you want to approve, and then if they want to come back with another application. There's nothing we can do about DEQ's timeline, considering the case here, and we've already gone this far with it. I can make sure that it gets expedited as best we can, depending on staff and time. And
So you seem to be arguing that they should take a continuance, period.
no,
And
I'm
go
actually.
and go and bring the other parcels back in some form that they think they can get some of them through the process, rather than taking an approval and a nothing, and a denial.
My personal recommendation, okay, so I'm going to emphasize personal, and that's it's a planning commission for to decide. I think the cleanest way is approve which parcels you think you can approve, and approve them today.
Yeah.
And then the applicant come back with a new application for the ones that are remaining that they think that they can get the Goal 11 exception on, so.
Because am I correct?
I'm not sure we can get there with a continuance because, like I said, some of these parcels already have septic approval. I'm not sure how we
Right.
would
Well,
get there.
So we'll need to formally deny the ones that we can't approve today so that they'll have to be resubmitted. And they can be resubmitted as a block, just for clarity for everyone in the room.
Yes.
Thank you.
And is that, am I total in this correct? We can approve, out of the 19 tax lots, we can approve 8 of them? Is that?
We can approve parcels A, or C, E, G, and L through N.
But can we, because they have
Yes.
They have
septic approval?
They have
Yes, they have identified
so
uses.
Huh?
They have identified uses.
those are all the parcels
I
that
know
meet
that,
the
but they
requirements.
also have septic approval, which
These are-
denies the Goal 11
No, these are the ones without,
exception.
these are the ones without the septic approval and the EFU.
So I did not include parcels A, B, D, F, H, I, J, and K, which are ones that are not identified, and some of them have septic or partial approvals installed.
It's basically the parcels that are vacant lots or are unidentified as what they use.
But it's still 8 parcels.
But it would provide the approval of the tasting
Right.
room, which Mr. Wallace is really
But
pursuing.
can they be approved on, because do they have identified uses?
Correct.
Yes.
Does that meet your approval? what Mr. Galpin said, naming those various lots.
So it sounds like we're talking about the, just to make it easy, the use table on page 32 of the record has the unused existing land uses and the ones that are specified in residential use, in use as a tasting room, vineyard, storage building, winery, pavilion, vineyard, and then portion as vineyard. So it sounds like that's what Mr. Zook is talking about, with the approval being the listed uses and the parcels associated with the listed uses versus the 8 unlisted uses and associated parcels.
So can you reiterate then the parcels that you think we could approve?
It would be the parcels associated with the winery.
I can list them for you. Those are parcels C, E, G, and then L through N. Those are all parcels that we can approve today.
6 of them.
L and all the M's?
All the M's and all the N's.
All the N's.
That's what gets into that whole tax lot versus parcel
So does
conversation.
that meet with do you agree with that?
Yes, I put in the staff report that,
All this.
that the
So the winery.
parcels associated with the winery, it was clear.
So that doesn't include C and, does that include C and D and G?
C, E, and G, and that's because those have
Oh, not D, E?
Yeah.
Yes, C, E, and G, and those
Sorry.
have specified uses. They're in residential use right now.
They would also be included
Correct.
under your approval.
Correct.
Entertain
Does
that motion.
anybody have additional questions for the applicant or staff before I close the public hearing? Does anybody have any additional questions for Mr. Waz?
So-
Go ahead and,
So, tax lots,
can I have you speak into the microphone?
those
Sorry.
three on the end, I, J, and K, is that right? I don't have septic approval on those. The criteria when we did the zone change 25 years ago required that we demonstrate that it was potentially feasible, and we did that in order to acquire the zone change. Those are going to be very difficult to put septics on because they don't have city water, so there has to be a well drilled for each one of them. The wells have to be 100 feet away. Those lots are divided by Highway 99 or whatever, that highway, right? Because in order to satisfy the 2.5 acre minimum lot size, we had to include property on the other side of the road. And so it's going to be very difficult to get DEQ to approve a septic on those. So I would like to include those under the understanding that they're going to be single-family dwellings.
And can we consider, this is a staff question or maybe a council question, can we consider testimony as part of the record in relation to the use table? So we don't have these unused uses, they're going to be rural residential, and that's now part of the record?
Yes.
You can make that a condition of approval if you want for those lots.
Yes, but we haven't determined, we don't have the DEQ determination that they can't be used yet.
Right, okay.
Or another applicable
So
letter from the
in
AEC.
that case, I mean, yes, you can take anything that's in a testimony here,
Sarah,
and
can
it's
I-
part of the record.
Yeah, sure.
But we still run into that snag if
Sure.
we don't have the DEQ part of it, so I don't think that's approvable.
Mr. Wallace, if you had a fair assurance that the vineyard or the wine tasting room would be approved, would it be okay to have a continuance for however long it would take and then come back with with a modification of this application that actually names these parcels that we think we can approve and add ones that you get more information on. Seems like it would make it much cleaner. We're kind of getting
I
spread
guess where
out.
I stand, to be honest with you, if you'll approve the tasting rooms in the vineyard, I'd just do that today, and whether I come back or not is.
Just not worry about the rest of
Not
it.
worry about it. If I decide to file another application and spend the money, then we'll do that. But for me to go back to DEQ, 'cause it sounds like you want me to go to DEQ and ask them to deny my septic. I'm probably not gonna do that, right? I've spent all these years trying to get DEQ to give me septic.
I hear you.
All I'm trying to do is make it better for everybody. But I'm not gonna go shoot myself in the foot and tell DEQ, hey, I need a denial, and then go through this whole process again. So I'm probably gonna submit for standard septic systems on those properties and figure out where to put them, if that's what I have to do. But since the pipeline's going right down the driveway of those properties, I just thought that we could put those in, and I may have to drill one commonly shared well in order to support those homes so that we can get the septics in without being within 100 feet, and each house won't have its own well. But as far as today goes, if we can get the ones you were talking about approved, I'd just as soon do that and be done with it.
Before we close,
Thank you.
before we close this hearing, Mr. Wallace, I do want to kind of remind you, it does sound though that staff will defer to DLCD, who is seeming to be open to interpretation outside of DEQ for the septic viability, just for your own future use in the future. So you may not have to completely go to DEQ. It sounds like DLCD is open to taking testimony from Alpine Environmental on the viability of septic installations on your property.
Okay. And you mean if I want to file another application?
Correct, yeah.
Understood.
Okay, with that, I will close the public hearing, and can I please have a motion to admit exhibits? And I don't even know how many there are.
Yeah, it's a lot.
We have 1 through 29.
I'll make the motion then to include those exhibits in the record.
I second.
Commissioner Schneider,
Aye.
Commissioner Galpin,
Aye.
Commissioner Elliott,
Yes?
Commissioner Lavanino,
Yes.
Commissioner Wallen-Daly.
Yes. All right. I think we can deliberate now, unless I would entertain a motion if anybody has one, but if you want to chat about it first.
No, I'd like to go ahead and make a motion.
Okay, Commissioner Snyder.
To approve C, E, G, L, all of M, and all of N.
I think you have to
I
read
think we
this
have to read it.
entirely, and then
The
put
whole thing.
specificity.
And then you have to amend it. Of
course I do.
Procedure.
As you go.
Sorry.
Okay, I'm not that good, so,
I'll do it. I would like to make a motion to approve based on the evidence and testimony. I move that the Jackson County Planning Commission approve a recommendation for approval to the Jackson County Board of Commissioners, planning file number 439-25-00005-LRP, to allow a minor comprehensive plan map and minor zoning map amendment for an exception to statewide planning goal 11 to allow the connection to a future Rogue Valley sewer line and to add 14 parcels consisting of 19 tax lots. Don't
can
we
I
have to
have
make
you
an
amend that?
adjustment there?
Other way
Yeah,
around.
an amendment
Please
there.
amend that.
I would like to amend that last line to include only parcels C, E, G, L, all of parcel M, and all of parcel N, and to not include parcels A, B, D, F, H, I, J, and K. To an area of special concern, ASC 2003-1, Goal 11 exception areas on a total of 790, what's the total acreage now? Sorry.
Oh,
thank you, Jack, for
I
taking this for me.
apologize.
I appreciate that.
anybody quick math?
Calculator, anyone?
I think you can just leave that part out for now.
Okay, thank you,
Thank you.
council.
Thank you, council.
Oh gosh, what's the zoning on everything here? With a mixture of zonings from RR 2.5 to EFU and Woodland Resource, located at, do we have to give a specific address to each one?
Do you have the addresses handy?
The addresses need to be mentioned.
He can leave blanks there, can't he?
I think it's all tied together in the record.
Or as amended in the record. And I guess that will close the motion.
Second the motion.
Okay. Any further comments on the motion on the table? Hearing none, clerk, please call the roll.
Do we want to deliberate first?
We have no comments.
No comments,
So
okay.
we're ready to go.
Commissioner Snyder?
Approve.
Commissioner Galpin?
Yes.
Commissioner Elliott?
Yes?
Commissioner Lavanino?
Yes.
Commissioner Wallen Daly?
Yes. Okay. Normally, we wrap up now, but we have another hearing, another item on the
Take a break.
agenda.
Let's
So
take a-
yes,
take a
let's
break. Thank you,
take 10, and I'll see everybody back here at 10:40.
actually concerned about you.
Okay, we'll go. All right, welcome back, everybody. We are now going to move on to the second item on our agenda, which is the consideration of a 7-lot subdivision with partial street improvement on 2 acres. Now I've looked in 2 places and I don't know where I am. Okay, this is a public hearing on consideration of a 2-phase 7-lot residential subdivision with a partial street improvement on 2 acres of land zoned White City Urban Residential 4. The subject property is located at 2912 Avenue A, White City, Oregon, and is further described as Township 36 South, Range 1 West, Section 20DA, tax lots 11300 and 11400. The application was submitted by Tyler Akins by agent Scott Sinner Consulting, Inc. There are a number of items that I am required to address prior to the start of this hearing. Approval criteria used in making this decision are listed within the staff report. Please direct your testimony and evidence toward the applicable approval criteria. You may also direct your testimony to other criteria or policies of the comprehensive plan, land development ordinance, or other land use regulations which you believe apply to the decision now before the Jackson County Planning Commission. Remember that a failure to raise an issue accompanied by statements or evidence sufficient to afford the Planning Commission and other parties an opportunity to respond to the issue will prevent appeal on that issue to the Land Use Board of Appeals. All participants who wish to speak must sign up on the sign-up sheet provided. The county is making a verbatim recording of the hearing. In the event of an appeal, it will probably be necessary to transcribe it. Therefore, when you testify or comment, please speak loudly and clearly so that your testimony will be recorded. Begin by identifying yourself so that anybody reading a transcript of the record will know who is talking. We need to have you clearly identify yourself with name and address for the record. Any written comments or other items of evidence must be submitted to the clerk to be marked as an exhibit for the record. The procedure for the hearing will be as follows. First, the commissioners will indicate whether or not they have had ex parte contacts or conflicts of interest. Second, we will have a report from county planning staff. Commissioners may have questions of the staff. Third, we will hear from the applicant. Fourth, we will hear from those in favor of the subdivision. Fifth, we will hear from those opposed to the subdivision. Sixth, we will then hear from those wishing to speak from a neutral position on the subdivision. And seventh, the applicant will have an opportunity to respond to any testimony or evidence. Testimony from the public and agencies will be limited to 5 minutes. Anyone needing more time to testify than allotted should submit their additional comments in writing. Finally, once everyone has had an opportunity to speak, the public hearing and associated public record will be closed. Unless the public hearing is continued by the commissioners to a future date, the public hearing will be closed for deliberation by the commissioners. At this time, I would like to ask the commissioners if they have had ex parte contact or conflicts of interest.
No.
Could we call the roll, please?
None.
Commissioner Galpin,
None, sorry.
Commissioner Elliott,
I have none.
Commissioner Lavanino,
None?
Commissioner Daly.
None. And I will now request the planning staff report.
Good morning. Thank you, Commissioners. Can you guys hear me okay? All right, for the record, Francisco Hernandez, Senior Planner, Jackson County Development Services, offices at 10 South Oakdale Avenue, Medford. Okay, so a little apology up front. This is my first foray into a PowerPoint, so it's a little middle school book reportish, but, you know, that's my wheelhouse. So starting off, as stated in the opening, this is a 7-lot subdivision with a partial street improvement in a White City UR4 zoning district. The property is 2 acres in size. Gross density would be 8 units. So just to give us an idea of the property location, you know, this is the zoning map in your record, and you'll see the property is sandwiched between Kramer and Hale. Okay, I know it's a little hard to read, but this is the tentative plan that was submitted with the application. And what you'll try to see is a partial street improvement along the east boundary of the subject property. What you'll see is that north-south orientation of that partial street, and then you'll see the I call it a semi-cul-de-sac turnaround north of proposed lot number 6, and then there's an eastern extension that runs along the north line of proposed lot 7. So the partial street improvement is allowed by the White City Code, and that really is the key issue here. And this is going to be for the benefit of the audience, just so they understand. There were significant concerns raised by the consumption of adjoining properties for the full street improvement. So what has been discussed with the agent is you're looking at about 14 and a half feet of abutting property to the east that tapers down to about 7.5 feet there at the turnaround. And this is really all about the timing of the partial street improvement. So it appears on paper that we're going to be consuming abutting properties that are not part of the application. That is the concern of the neighbors. And so working with Mr. Sinner, the agent, and determining how things work in the real world, the consumption of the abutting property, that 14 and a half feet tapering down to 7.5 feet, on those properties to the west, that doesn't happen now. It does not happen until those abutting property owners go to develop. And by develop, we mean either partition or subdivide their properties. So there's no taking that's occurring, there's no consumption of someone else's property that is occurring. And so it's important, and again, for the benefit of our audience and the commissioners, it's important to understand that neighbors don't have to do anything right now. The only thing the neighbors really need to do is decide if and when they want to divide the property. And at that point, they will pick up their portion of that private road improvement, what's left of the travel surface, curb, gutter, sidewalk. And Mr. Sinner will get more into the details and the value added and the cost of improvements down the road versus the cost of improvements that his client will bear. But anyway, I digress. Really the key here again is for everybody to understand the neighbors don't have to do nothing. With the recommendation of denial that you have in front of you, it was all about the timing. Staff was concerned that there was going to be a consumption of that neighbor's property if this went through with the recommendation of approval. Again, staff and Mr. Sinner, we've talked, I understand how things work again in the real world, and there, again, no consumption of abutting properties is occurring based on this design. Mr. Sinner has proposed an alternative design, eliminating that easterly connection to Agate Meadows, 3 properties over, until talk more about that. From staff's perspective, knowing that the partial street improvement standards can and will be met, knowing that abutting property owners aren't going to be encumbered until they choose to finish the street, working with Mr. Sinner, staff is 100% confident that we can return with a recommendation of approval, and that the development with the modifications checks all the boxes for a subdivision in White City, similar to what you see to the west on Kramer. So with that, I'll take questions.
I guess one question kind of glaring to everybody who read the record so far. If you do include others' properties into this proposal, it'll make the other ones illegal. In other words, if there's 8 developments per 2 acres, or 4 developments per acre in the mobile home park especially, you with me?
I'm not
So
tracking.
that makes, then they're at the maximum development right now.
The
So if you
subject
take
property is, yeah.
15 feet or 5 feet or 2 feet away from those parcels, they're going to be illegal. That's kind of painting ourselves in the corner, isn't that correct?
No, no, it won't. So with the size of the abutting properties, and again, Mr. Sinner will go into more detail with this. So those abutting properties to the west, so they're still going to be wide enough, deep enough. They will have enough land area, even after the rest of that partial street is built out, in order to achieve their maximum density. They can still achieve minimum 8,000 square foot lots, and it won't be an impediment. And it won't cause them to be illegal. It won't somehow trigger some retroactive unlawful, parcel status. No, it really, at the end of the day, and again, Mr. Sinner will go over this in more detail, it really does benefit those property owners to the west.
Was that disclosed in the record then? I guess I missed that part where you described that.
So, no, it was not in the original submittal, but Mr. Sinner has provided, a future build-out demonstrating those abutting properties can meet their allotted maximum density and meet their lot size.
Because it stated in there that they're at maximum now. They can't put any new lots on, I guess, but the existing lots are within the 8,000 square feet.
So with respect to the mobile home park, is
Yes.
that what? Oh, with
That's
respect to
mainly
the
what I'm
mobile home.
talking
Oh,
about.
okay, yeah, with respect to the mobile home park, yeah, they've got 8 houses out there now, if I can believe an aerial. So thinking that there was going to be a way for them to subdivide potentially and then get an east-west connection to align with Agate Meadows just didn't look feasible. So, and then that is one of the nexus for the modification of the tentative plan and eliminating that east segment.
Is it legal?
Is the mobile home park legal?
With the new constraints of adding more land to contribute to the road right-of-way?
So, the mobile home park?
Isn't that what I'm reading from that, I thought?
So the mobile home park, so the fear would be that if there was land taken away for a public right-of-way, then that mobile home park may not be able to meet maximum density. That would be.
No, it's already reached maximum, so you're taking away from it, so that would make it
potentially
illegal
lose.
for the existing development.
No, I don't think we're there yet. And I don't, no. So they would enjoy pre-existing status.
Yeah, we can hear from the applicant, maybe he'll clarify that. but
Yeah, maybe that'd be a good idea.
I'll defer that for later, okay?
Yeah.
Do we have any
I
other
just might
questions?
jump in there. If the mobile home park is legal, it's already approved. So even if there was some land that was taken away and now the density wasn't what it was supposed to be, it's not a new application. They're still legal.
Because it's a pre-existing
Yeah, they're
approved use
pre-existing,
and all of
they're
that.
already, they already are approved by their existence.
So a right-of-way won't affect the status of that
But can
parcel.
they,
Won't affect their legality.
Their legality.
If they were to do new
They wanted to-
development in the future,
Potentially.
that would have to be part of a review at that time, but it doesn't affect their legality now.
Okay.
so you can give away part of your approved property somehow and still be a legal entity?
If you're pre-existing,
That doesn't make any sense.
So
Kristen,
The- the-
save me on this
the
one.
appli-
John has hard questions.
the applicant, let the applicant, it's been redesigned. There is going to be no easterly road.
So we're worrying about this over nothing?
Yes, perfect. So
could've
if you,
said
if you, sorry,
Slap me next time, but
we'll get there.
Okay, does anybody have any other questions?
Never
for
mind everything I said.
Does anybody have any more questions for staff?
No.
No.
They've all been answered now.
Apparently. Okay. All right, then I would like to open the public hearing, and we will start by accepting testimony from the applicant. Name and address for the record, please.
Good morning, Commissioners. My name is Scott Center Consulting, Inc., 4401 San Juan Drive, with an office in the garage at Suite G. We are here today to try and request a continuance. We've got, I never like to go into a public hearing or a decisional approval or denial with a recommendation for denial. And staff and I have been working very feverishly to resolve some of the issues that were within the staff report for denial. Primarily, it deals with this partial street improvement. The main part of the Jackson County Land Development Code doesn't provide for partial street improvements. Only Chapter 12 does, which Chapter 12 deals with the urban development within White City. And within that, 12.8.1 provides for a partial street improvement. And that's where one developer, we're talking small lots here, these are 8,000 square feet, which are large single-family lots for White City. But it allows for us to put in a partial street improvement, which is half plus a minimum of 8, and we're going to a total of, this is a full improvement of 45 feet. And we're going to provide a minimum of 30 and a half feet. But the misconception of the partial street improvement was that it was resulting in a taking of our neighbors' properties over here. And that's not the case at all. The code is very clear. It says that when a development puts in a partial street improvement, it must be able to demonstrate that when the other properties develop, they will be able to develop. Currently, the adjoining two properties, they're 116 feet wide, and we will have developed the majority of the street on our side, leaving a 7.5 to 15.5 foot dedication required when they choose to develop. And that will result in a remainder of over 100 feet. They'll be able to do 8,000 square foot lots that are appropriate for the zoning district. And so that partial street improvement is the one big clarification. Can we turn this on? Or is it on? Do I have to do anything? Okay. Sure.
All right, we're just going to take a moment while we get some copies. Just kidding, we have it up here. We've been looking at it.
The redesign?
Yeah.
Okay. I'm gonna.
It's stalled out with him.
Stalled out, so.
Stalled out. I was having
Okay.
had a question from that later.
Okay, I want to walk up here
Oh,
just
I wondered
to
if
make
that's
sure we're talking about the same thing here.
Oh, yeah, you can come here.
Take the bulb out.
You had a good question.
Turn the bulb.
So
That's a
this
good
is-
idea, Scott.
This is our actual submittal. It's a little bit different than the
Oh.
conceptual.
Still the same
Oh, we
concept.
got a bunch now.
Here we go.
It's similar to Word. Okay.
I don't know if this is the same as that one, or, I don't know.
There's.
Yeah.
So, so one has a full street improvement on our property. I'm going to get back to this, so I'll address it.
Okay.
Oh, I see.
The 11 by 17s that you have in the record was an initial concept, and it showed that we could successfully put a full street improvement on our property, and that we could also do the partial street improvement. And we are going to be proposing the partial street improvement. We are also asking for a continuance because this is all new development. It's been in flux, and we would really like to see a clean, consolidated record that shows, that makes it easier for you folks to review and make a decision on. So we're asking for a continuance to the 23rd, which is the next hearing. Now, what we have done is we've put a cul-de-sac bulb, and we've improved, or it's an offset cul-de-sac. So the bulb is actually fully on our property. It provides the full turnaround for emergency vehicles. And then we also eliminated the stub to the east. So the partitions that happened a couple of years ago with the adjoining properties, they don't have any dedication requirements. The mobile home doesn't have any dedication requirements. There will be no connection between Hale and Aikens here because of the existing development in the way. So we provided the revised plat, and then I'm going to walk this one up. This demonstrates that there will be future development potential from the adjoining properties.
So in a way, you have benefited the other property. I won't go any further.
So there is a significant benefit to the adjoining property owners. When they choose to develop, they will be able to tap into the facilities that we've provided. They won't have to extend out to Avenue A. They just tap there. So it would be my estimation that our construction cost on this is probably about $40,000 a lot for doing our partial improvement and our taps. And I would anticipate the adjoiners would be probably a third of that cost. So there's a significant financial benefit when they choose to develop. But at this point, I'd be happy to answer any questions. And I'd also request that we continue to the 23rd. I've had a brief discussion with the neighbors to tell them, number one, we're not taking any of their property. Number two, we've got a redesign with the cul-de-sac that prevents anything from going to the east. And they seem to like that idea, but I think we'll hear from them.
So will it be, it's a public street?
Public street.
And they will get equal access from it when they
Yes.
develop?
Mm-hmm.
So, yeah.
Six new potential lots that could be benefited from this road
Correct.
construction.
And there would be no future plan to straighten out the bulb. That's permanent.
Correct.
So they have all the benefit.
They have all the benefit.
Gotcha.
So in your plan, I didn't get that clear in reading the documents. You have two phases involved here. We still have two phases?
Yes.
And phase one, is that lots 1 and 2?
It's lot 1. It's lot 1 with no improvements. So all we're doing is we're separating the house from the development property.
So phase 3, or 2, I'm sorry, would be lots 2 through 7.
Yes, and the full road construction.
And you're asking for, well, you're going to tentatively continue this on the 23rd. What month is that, like next month?
It's this
April.
month.
It's this month.
2 weeks.
2 weeks, got it.
We would much rather continue to 2 weeks than have a record that isn't as clear and concise as it could be.
Okay, that's it. Thank you.
Does anybody else have any questions for Mr. Sinner? All right, thank you. And do we have a sign-up sheet for this?
You do.
Hearing?
Right here.
Okay, thank you.
Point of order, would I have a rebuttal or not, since it's a continuance?
You can reserve time
Okay,
for a
I'd
rebuttal,
like to
yes.
reserve.
Thank you so much. Okay, could I please have Luis Cortez come up? first.
I live on 7408 Primavera Street. Our only concern was that of them using our property or our private driveway, because we spent a lot of money on constructing that. We just didn't want them to ruin what we had built already. But he had explained it to us already that they made new plans and weren't planning to continue with that. That was our only really concern of them using our property.
Okay.
So Mr. Sinner's plan has alleviated that concern?
Yeah.
Thank you.
And then I have Maria, oh, I can't read it. Valle? Come on up.
Good morning. I live in 7414 Primavera Street, and I'm here with the same concern because the old design that they made was they designed a street where my house is. So, and I was not agree with that, and I was not happy with that. But he told me that they changed the design, so I have no concerns since they don't touch my property.
Okay.
So if they don't touch my property, I have no problem. But I don't give permission for use my property for anything.
Right, okay. Thank you very much.
Thank you. I'm sorry for my English is not
No,
good.
no, you did great. It was great. And then Jose Martinez, are you here?
Well, it's basically the same thing.
Could you please state your name and
yes,
address for the
Jose
record?
Miguel Banuelos, and I live on 2A70A Avenue A.
Thank you.
And it was like the same concern, like part of the curve that they want to make, it was like on my road, in my property, sorry. And I was like, okay, wait, why did I, no one tell me anything about it. But he already explained me something, and yeah, for sure I got no problem right now. But if you can you give me like a copy just for sheet of paper? Yeah, and yeah.
Excellent. So your concerns were also addressed by the applicant?
Yeah.
Okay.
Yeah, for sure. But it's still like, I want to see
Yeah,
the
he'll
paper.
show you.
Yeah. Yeah.
Excellent, thank you. All right, it looks like that's everybody who was signed up to speak. So I believe I would entertain a motion to continue the hearing to April 23rd, if there's no other comments. Unless, Mr. Sinner, did you want to come up and just?
No, thank you.
Okay.
Madam Chairman, Chair Lady, I move to continue the public hearing for Jackson County Planning File Number 43926000005 SUB to April 23rd, 2026 in the Jackson County Auditorium. That concludes my motion.
I second that.
All right, please call the roll.
Commissioner Snyder?
Yes.
Commissioner Galpin?
Yes.
Commissioner Elliott?
Yes?
Commissioner Lavanino?
Yes.
Commissioner Wallen-Daly?
Yes. I think that concludes our business for the day.
Ask a couple questions.
Yes.
First of all, do I need to extend any time deadlines with an email? I think we're well within the 120 days.
Yes, you're fine.
Okay. And then is it going to be a new public hearing? Okay.
It's a continued public
Okay,
hearing,
so okay, good. Thank you.
we haven't-
Is that going to be at 9 o'clock?
Is that our only application that day?
Yes.
Yeah, okay, so it'll be at 9, yes. All right, I think that's everything we have for today. So with that, I think we can, do you want to fill us in on anything coming up before we adjourn? Ted does.
I just want to say, I'm not going to be here on the 23rd. I have another meeting, but it sounds like this one's going to be, hopefully, pretty cut and dry. Tentatively, we're looking at April 28th for a third-party consultant to come and talk about... May?
May 28th?
28th. We're have a, thank you, Christopher. I should just let you do the update. May 28th, third-party consultant, we had some grant money where they were going to look at rewriting some of our land development code and cleaning it up. I say that's tentative because we want to make sure that what they bring to you is something that's ready. And then on May 14th, Josh LaBombard from DLCD is going to come and speak to you about the role of Planning Commission and how they interact with DLCD and the OARs and all that. I'm hoping that on that one, I'll be able to give you the legislative update also. I didn't want to do that today because you had a lot on your plate today, so. Future upcoming attractions.
We're going to have 2 meetings this month and 2 meetings next month.
Who are we?
Is this a whole new world that we're entering?
Yeah, it's, I'm glad you said cool.
Excellent, all right.
Careful what you wish for, John.
Thank you, Ted.
Patty, I won't be here on the 23rd. I'll be out of town.
All right. Any other items for anybody?
Since Ted's here, maybe we have a annual meeting scheduled, coming up soon with the county commissioners, and a plan of action for 2025.
That's a good question. I don't have it set up yet, but thank you for that reminder. I'll get it moving.
We usually do it in November anyway,
Yeah, I
so
know.
it's, it's a pre-planning
after
meeting.
the fact.
It's totally fine.
I know the one year we had it right on Halloween, so that was good.
Right.
Excellent. All right, we are adjourned. Thank you.